Shashi sir, please share the YouTube link also in the group. Yes.
Wait for a second.
So should we start now? Yes, sir.
Conference also.
Okay. Let me check. शशि सर एक्चुअली नवगीत ने वेटिंग रूम में है, अगर आप देख सकते हो उसको तो इन कर लो। हाँ, देख लीजिए प्लीज. And if other participants are facing any issues, right, so we will share the YouTube link with all of you, so don't worry about it. Shashi sir, please group में ना YouTube link share कर दीजिए. Yes. So Kapil sir, should we start now?
Yeah, ma'am, sure, ma'am.
Yes. So स्पॉटलाइट डाल दीजिए कपिल सर और मेरे पे, है ना? Okay, so I'm starting. Right. So let me share my screen first. I hope my screen is visible.
Yeah, ma'am.
Yes. So, dear participants, a very good afternoon, everyone. I welcome esteemed speaker of the day, Dr. Kapil Arya sir, our worthy ma'am principal, Dr. Principal Professor Atima Sharma Divedi ji in her absentia, and Dr. Rashmi Sharma, she is President KMB IIC, and all the students and participants from all over India with great joy and immense exultation. I, Dr. Narinderjeet Kaur, in charge KMB IPR Cell and IPR Activity Coordinator KMB IIC, welcome you all on behalf of whole KMB family on this 3-day national workshop on intellectual property rights by KMB IPR Cell in association with KMB IIC. It has become a regular aspect and part of Kanya Mahavidyalaya to organize such academical programs. So before starting, I just want to say a few words about our institution. Kanya Mahavidyalaya, the autonomous and heritage institution, is celebrated for its colossal contribution to women education across 3 centuries of its glorious existence. A multi-faculty postgraduate pioneer institution, KMB has been accredited A grade by UGC NAC, awarded the status of college with potential for excellence, star college status by DBT Government of India, top national rankings as per India Today survey, ranked number 1 autonomous college in Punjab by Outlook magazine, and it ceaselessly strives to open up new vistas of learning and to emancipate, enlighten, and empower women. So let's watch the glimpse of our heritage institution, KMB. So let me share my screen again. Yes. Just a minute, please. Yes. I hope the sound and Shashi sir, is it audible?
Yes, ma'am.
In a
Yeah.
very vibrant, energetic campus life at KMB, we nurture young women who are confident, ambitious, and equipped with the right skills to face the challenges of life. Here we have the ideal amalgam of traditions and modernity. Education at KMV is focused on preparing global citizens who will be the leaders of tomorrow. Personal care, warm and safe environment for girls at KMV helps them to thrive, dream big, and achieve high goals in life.
Come join the winning journey at KMB. Become future ready with KMB. Be the best with the best.
We welcome you fervently, young girls, to Kanya Mahavidyalaya, Jalandhar.
So this was the glimpse of our beautiful heritage institution KMB. So let me introduce the speaker of the day, um, Dr. Kapil Arya sir. So let me share my screen again. So we welcome you, Dr. Kapil Arya sir, the esteemed speaker of the day. So let me introduce Kapil Arya sir. He is senior scientist in Innovation Protection Unit, Council of Scientific and Industrial Research, New Delhi, PhD, and postdoctoral fellow in chemistry and PG diploma in intellectual property right management. He has more than 15 years of experience in field of chemistry, intellectual property right management. He has drafted and prepared a legal document of more than 400 patent applications received from various CSIR labs, more than 500 foreign patent applications reviewed and prepared final documents of office examination reports of patent applications in the field of chemical sciences and submitted to various foreign patent office, reviewed 300 Indian patent office examination reports and new patent applications in the field of chemical sciences, biochemistry and material chemistry. He also prepared response drafting the patent application and hearing notice response and submitted to Indian Patent Office, Delhi. And he has a very big achievement of that he filed 50 copyrights, 40 numbers of trademarks, 20 designs, 1 GI filing. So we have among us a very eminent speaker of the day, Dr. Kapil Arya sir. So over to you, sir. We welcome you, sir, in our institution.
Thank you, ma'am. Thank you for your kind introductions. And today, just I'll share my knowledge of trademark, copyright, and design among you. Just I'll share my screen to you, and hopefully my screen is visible and I am
Yes,
audible.
sir. Yes,
Yeah,
sir. Yes, sir. Yes.
yeah, sure. So first we start with the essential of the trademark design and copyright. And before we start about the trademark design, copyright and patents, we start from what is the intellectual property rights. So the intellectual property right is the creation of human minds in term of the innovations or literary activities, artistic activities, work, designs, and symbol, image, etc. All these are come under category of the intellectual property. These are intellectual property is the intangible assets of creation of human intellects, and the intellectual property rights are the rights associated with these intangible assets, so that the person who have creators or who have inventors protect their rights against without use of her and his consent with the other ones. So it's intellectual property rights give a exclusive right to creator to use of her or his creativity for certain time of the periods. And there is a lot different type of the intellectual property in the example of the trademark, copyright, patent, design, and geographical indications also. And when we see the in scenario of the Indian Patent Office, the and the intellectual property right in India, so there is several intellectual property rights governed by the several rule and regulations, like the Copyright Act 1957, Patent Act 1970, Trademark Act 1999, and GI Act is 99, Design Act 2000, Semiconductor IC Layout Design 2000, and Protection of the Plant Variety and Farmer Right Acts. And these all these intellectual property have some validity of periods. Like we are not a lifelong protection of these intellectual property rights, because all these have governed with the several acts and rule, and they have some validity. Like the patents have the maximum protection 20 years, and we have to renew every years of the patent application if they granted. And if we are failed to renew our granted patent applications, then it is automatically abandoned by the Indian patent, lapsed by the patent office. And the patent is governed by the Patent Act 1970, which is amended time by time. And, and in 2005, they amended in Patent Act. Trademark also have lifelong protection, but we have to renew the trademark application after 10 years. And they're governed by the Trademark Act 99, which is amended in 2010. Designs also have 15-year protection maximum, and after 10 years, we have to renew for next 5 years. And it is governed by the Design Act 2000 and Design Amendment Rule in 2014. Same, the copyright have the lifelong protection, but in case of the death of the author, the legal hire having the maximum protection is a 60 years, and renewal is not necessary in term of the Copyright Act. And in geographical indication also have the lifelong protections, and after 10 year we have to renew. And validity of IPR in geographical indication is the geographical indication good registration and protection at 1999. So when we start about the first about the trademark, so what is the trademark? As you can we can differentiate between the trade plus marka. The marka which is used for the trading purpose. So just like the Adidas, Pepsi, Coca-Cola, all these are the example of the good trademarks. Through this one, the particular company have trade their objects. So when we see the branding and the trademark are very key success in the business and or in the global market. So this is in this example, the Adidas and Abibas both have some different name, but Adidas have the superior quality or having with the Abibas. So when there is a two things, Abibas and Adidas, so would you prefer authenticity or a quality or a cheap knockoff? So it's give the trademark give us the actual picture of that products. So based on that, the person or a consumer can identify that their products having the certain quality of the live objects, and so that he can purchase it. So when we see another examples, so there is a one example of MACD and some other having not a, MACD logo. So the MACD without the logo of the MACD, it's having the rest 10 rupees, but the when we put the logo of the McDonald, it's having the 100 rupees. So the branding is the reason. So that's why the people pay 10 times more for the logo. So logo having the more valuable assets for the branding or branding or for trading purpose. So when we branding is when we in that according to the definition of the branding, so branding is the process by which the name or identity of the company or enterprises or organization is communicated. For like the MACD logo means McDonald, or a Maruti logo means the Maruti. So through this logo, a company or a enterprises or a organization is communicated. And the branding also a company to differentiate its products and service from competitor by creating a bond with the customer also. And it's a way by which the companies launch and sell the goods and service, communicating the essence of new products and the lines. And it's also reflect the prestigious or aesthetic image in general publics to order to attract the more consumers. So this is the best example of branding of the Coca-Cola study. Because in 2016, because in 1886, the Coca-Cola is first invented in Columbus, Georgia. This is not a sipping soda. It is originated, invented as a medical beverage, and it is advertisement as a help in the relief of headache. But the after in 1892, the Cadler procure all these in Coca-Cola, and he give the strategies so he can sell their in the market as a sip or sip soda. So the Coca-Cola target audience is the based on the age, income, and their family size. And the Coca-Cola just give the wide product range, and the Coca-Cola also have the very classic bottles and the font and the logo size. So in the advertisement of the Coca-Cola and based on the market strategy of the Coca-Cola, so it's make the Coca-Cola in global advertisement, branding, and portfolio marketing. So in the Coca-Cola introduced 120-year backs, but still the most sipped soda in the worldwide due to the robust marketing. Because in the absence of the robust marketing, it cannot be happens. Because because the Coca-Cola, firstly the company target young people which are having the age 10 to 20, 35, and thus they use the in the celebrate in their advertisement to attract them in the eve of the Valentine Day. So the more and the more young people come attract and taste their soda drink or a beverage. They also target the middle age and the older adult who are the diet conscious or a diabetic by offering the diet coke. So they have the wide product range, and they also work on the income and the family size also. It introduce the packaging and the size price at a various level to increase the affordability and the target students, middle class, and the low income family or individuals. So when we think about the trademark, so trademark is just like a visiting card, a kind of visiting card that promote the image of company is the range of the goods and service, or we can say it is the sign which is the distinguished goods and service produced or is sold by one enterprises from other enterprises. So the trademark having a marketing tool, it is a source of revenue generation through licensing or a crucial component of the franchisee agreements, or it is the useful for obtaining bank or a third party license. For example, Apple having the good reputation in the markets or their logo on the based on their logo and a good reputation in the market, any one bank can give the finance to them. But the lower company which having the no logo, no reputation in as such as the Apple, so the bank also afraid to give the finance. So that's why the trademark is the useful for obtaining the bank or a third party finance, and it is also a valuable business assets. So the trademark perform two critical function in the marketplace. First, they provide the assurance that their goods are having the certain quality and consistency, or they assist the consumer in the making decision about the purchase of goods. The main purpose of trademark is show the difference between the quality of goods and their services. So first the trademark when we trademark act story. In 1940, the British government passed a trademark act for uniform and systematic registration of the trademark. And after that, in 1958, the trademark or merchandise act come under exist in India. But the actual trademark act come under existing in 1999. And according to this act, the definition of the trademark expanded and the service mark introduced and multi-class filing allowed and registration and renewal period increased up to 10 years. And after that there is a several amendments is happen in 2010. There is an amendment in act. So through international filing of the trademark application, the Madrid protocol come into force, and the notice of opposition period changed to 4 months. And after that the trademark rule also amended into come under existence in 2002, which is amended in 2013 and 2014. And through this trademark rules amendment, the fees of the trademark filing is increased. So there is a two things: registered trademark or a unregistered trademark. When we when we registered our products, so we have, there is a statutory remedy, but in case of unregistered trademark, the common law action will be applied. In case of the infringement, the registered trademarks having the value, onus on the third party, but in case of unregistered trademark, the onus on proprietor in case of trademark only. So this is in India perspective, the India just applied a common law jurisdictions, means the use of trademark take place precedence over the registrations. So registration is some case entitled the prevention of the use of mark even in class other than those protected. When we file the trademark application, there is a multi-class. So the when we apply our patent and trademark application, so we have to mention the in which class we have to apply. But in the some case or some case, the registration of a particular trademark prevention to use of mark even in class other than those protected. In case of the infringement, the police insist on the registration of the mark for enforcing right by way to search and seizure operations. So in the trademark registration, just like a patent application, trademark also having the territorial in nature, means if you have registered in India, it doesn't mean that your trademark is protected abroad. So if we have the wider protection, we need to file our trademark application in foreign country as well as in India. In through foreign for foreign filing, if the country is member of the Madrid Union for the registration of the trademark administration by the WIPO, and the advantage is there, the member can also apply for other member country with one applications, one language, one set of fees, and renewal also a single procedures. So in the trademark, the first trademark was filed in 14th century, and Bass is the first trademark. Bass and Lowenbrauer is the beverage, is filed in Germany. This is the first trademark. The watermark is there is a several example of the trademark applications, trademarks, just like the watermarks imprinted on the papers, baker mark on the bakery products. So this is also an example of the trademark. So there is some well-known example like the Coca-Cola, Hutch, Adidas, Spritz, Gillette, Mastercards, McBay. All these also having the good example of the trademarks. So based on these marker, we can identify the goods and their origins. So and it's a way guarantee of the unchanged quality of the goods, and it's act as a marketing and advertisement tools. So when we think about the fundamental protection, fundamental principle of the trademarks, so this is the example of one car. So car is not a subject matter of the trademark filing. The whole car or the aesthetic of the car, means the shape of car, is a subject matter of design filing. And the engine is not also a subject matter of trademark filing or a design filing. The engine is a subject matter of patent filing, because through engine that create the automatic history, how what is the part of the engine and how these part are come together and give the function of engine. So the engine is the subject matter of the patent filing, but the logo which are on the car is the subject matter of trademark filing or a copyright filing. So the logo is a subject matter of trademark filing. So there is a different type of the trademarks, like the associate trademark, collective trademark, certification mark, wellness.
Sorry to interrupt you, sir. Your camera is not visible, sir.
Yes,
Your
ma'am.
video. Yes, sir.
Yes. One minute. Yeah. It is visible?
Yes, sir. Now, now it's okay.
Okay. So in trademark types, one is the product marks. Product mark means to distinguish service one service to other service, like the Amul. Amul is the example of the Taste of India, Nestle, Mother Dairy. All these are the dairy products, and through this logo, we can distinguish one product to the another product. Same the service marks. Service marks means to distinguish the service, like the MACD is the commanded to beverage sectors, Air India for the tourism sectors, Upmax Healthcare is the health sectors, Google is the communication sector, Apple is the telecom sectors. So these are the service marks which is the distinguished the services. The collective marks means distinguish goods and service by member of association like the Tata Sons, VI, Vodafone and Idea. Vodafone also one company and Idea is another. So Vodafone and Idea come together and it is the example of the collective marks. Tata Sons. Tata Sons is the collection of the particular companies. So the marka used for distinguish the goods and service that are provided in produce to member of organizations is the come under category of the collective marks. That certification mark for certification purpose like the ISO, ISI, wool marka, good housekeeping. So all these are come under the category of the certification marks. Safe mark, safe of the chocolate, safe of bottle of the Coca-Cola, safe of car are come under to the trademark filing of the safe. The pattern marks means the marker consisting of the pattern which are capable of identify the goods and service as originating from the particular undertaking. The small marker EVA. EVA is also a scanting success. So this is also a trademark filing, smell marker. Sound marker, sound of the window, sound of the Doordarshan, all the Intel sound, Nokia tune, Samsung Galaxy tune. So all these are the come under category of the sound mark trademark. The well-known trademark is Apple, Microsoft, Amul. All these are the well-known trademarks in relation to the any goods or a service means the marka which have become so substantial segment of the public which use such goods and receivables. So when we think about the trademark, the any marka capable of graphical representation bearing the ability to distinguish the goods and service, it can be a word, it can be a name, or it can be a signatures, it can be device or a color or a textures, it can be a graphics and motion, it can be a smell, it can be a sound or a shape. So this is the example of the trademark application. In one chocolate box, there is a several type of the trademarks applications we can file, like the textures, the colors, the word, label or a device, safe, packaging. All things are the subject matter of the trademark filing. So when we the things that are not eligible for the registration of trademark is the use of which are likely to be deceive or a cause confusion is not a subject matter of trademark filing. The marker which comprising a scandalous or a obscene matter is not a subject matter of trademark filing, and the marker which comprising or containing any matter likely to hurt the religious sentiments of the any class is not a subject matter of trademark filing. Even the national flag, name of national leader, Satyamev Jayate, all are these not a subject matter of the trademark filing. So there is a difference of the registered or unregistered trademarks. The advantage of the registered trademark is the protection and the unregistered trademark is the not protected. In case of the infringement, the owner of the registered trademark can get a legal remedy in case of infringement, but in case of unregistered trademark, the trademark get remedy under the common law action. And the symbol is the R for the registered trademark or TM for the unregistered trademark. So how to choose the trademark when we come into the market? So we have to think about what type of the trademark we have to choose, because because the products are made in factory, but the brands are created in our minds. So we have to choose the stronger marker for purpose of the trading of our things, our objects, and the weaker marker is a very generic and descriptive and suggestive, but the stronger marker is arbitrary and the fanciful. The example of the unique and fanciful marker is the Nike, Pepsi, Kodak, and Xerox. And word and device which are arbitrary in natures like the BlackBerry. BlackBerry is not a is a logo is used for the selling of the phone, but BlackBerry is just like a fruit. Same the camel. Camel is the animal, but actually the camel is not a trademark are used for the selling the animal. It is a used for the clothing brand. Same and the mango. Mango is just like a fruit, but is just like a clothing brand. So we have to choose our trademark which are the arbitrary in nature. and the trademark which are the easy to remember, like the Dunkin' Donuts, Coca-Cola, PayPal, Band-Aid. So we have to choose in this case in such a way that it is easy to remember to person, and the marker that are very suggestive and yet fall short on being descriptive, like the Baby Dry, One Words, Timex. Or we should avoid the generic marks like the battery or etc. So generic term like we should avoid like the chair to sell chairs, descriptive term like the sweets to sell the chocolates, and descriptive term like the pure wool for 100% synthetic material, marka and term like the which are the contrary to the public order, or in that in our trademark there is no use of flag, emerald bearings, official hallmarks, emblem without a legal authorization. So the when we select the trademarks, the our trademark application is arbitrary, just like a apple for computer, suggestive mark like the sunny for heaters, and they are easy to remember. And we have to think that our trademark application is no legal restrictions or reason for rejections, like the when we search the trademark which are already granted, so it is not a identical or a confusingly similar to existing, like the Twitter or Twitter, because the Twitter or Twitter having the same pronunciations. So in that case, the we should avoid such type of the confusing thing. Gincona C or Zircona C, because the Gincona and Zircona almost having the same or a confusingly to each other. So we should avoid when we draft the trademark in our products. And the suitable for export material which are corresponding domain name which are not already used. So our trademarks can be inherently distinguished in natures, and it can be acquired or distinguished through the long or exclusive use, and these are the arbitrary in natures, like the apple for computers and now many or other things, and Ariel just like a cleaning solutions, Subway like the restaurants, Reliance Press for the retail shopping center. All these are the example of the arbitrary. And the fanciful example is the Nikon, a electronic instrument, suggestive like the copper tone, a tanning solutions, Mustang is like for a car, and the good examples. And descriptive like the example of Mochi for the shoes. And these is the in case of the descriptive, the one step further down any descriptive trademarks, these cross a significant boundary because they are not a inherently distinguishing natures. They can acquire the distinctness, but they are not protectable as trademark right away. The Best Buy, the retail store, the Bank of America, like the bank. And it is also important to know that the surname can sometimes be considered descriptive. And in addition, any laudatory terms like the best, super, primes are also considered descriptive, and we should avoid when we draft the trademark. And the generic term is we should also avoid, because a generic term is simply a commonly used term to describe some things, and it is become a very hard to enforce. So this is the example like the Colgate is the coin word, and the Domino's pizza is a arbitrary word, and they having the inherently distinguished natures. Same the sunglass is also a descriptive marks. Pizza Hut is also a descriptive mark. So sunglass plus hat and the pizza plus hat, they in through the combination of two words, they give the acquired distinctionness in their trademark. So in the trademark, when we file the trademark application, so there is a different class of trademark applications. So the class 1 to 34 is the subject matter of the goods and come under category of the goods, and the 35 to 41 classes come under the service classes. So when we file the trademark application for the chemical products, our trademark application goes under to the class 1. For the patent and other one is the come under category of class 2. And for the service, for a education service, like when we when we discovered any app, and this app is subject matter for education purpose, so it is come under to category of the class 41, as well as the the class 9, because the class 9 is a subject matter of the scientific and electrical devices, and the class 31 is the educational as a cultural activity. We can file the multi-class, but we have to file the separate application, separate, we have to file the separate fees for the each and every class trademark applications. And in case of the ordinary trademark application, a single class of good and service, and in case of the multi-class trademark application, we there is a provision to the file a multi-class of the goods and service. And in case of the convention trademark applications, we can take a priority from the convention country. Convention means the we can also eligible for the file the trademark application in foreign jurisdictions. So a conventional trademark application refer to the application for registration of trademark claiming priority from the convention country, means India. And the provision of the registration of the name of chemical elements and the international non-proprietary names like the certain pictures, name of gods, goddess, and the religious heads which are prohibited from the getting the trademark protection by the notification of central governments, like the Bharat Scout and Guide, Lord Buddha, Guru Gobind Singh, Pansil, ISO, etc. And in the well-known trademarks, the Biocon for pharmaceutical preparation, and the business administration and retail outlet and research, Mother Dairy, Raymonds, all these are come under to the well-known trademark. So in when we file our trademark application, we should also keep in our mind for the color of that one, because color of our logo, because the color black and white logo have the broader protection. So the registration a design marker in black and white without a color claim means generally provide a broader rights and more flexibility in the use. Without a color claim, the trademark owner is free to use any color or in no color at all to support the registration. But when we file our trademark application in a particular color, so the any other person can file the other color, and it is a subject matter of the granting of the trademark application. So there is a best way to file first the trademark application in black and white. Black and white color black and white logo give the broader rights, and it's cover the all colors. So the big company like the Starbucks coffee, FedEx, Apples, their first trademark application is the black and white, and after that they file the color trademark applications. So in the trademark filing process, there is a requisiting information. We need the applicant details, user information, or a user affidavit in case of use claim, and in case of logo, device, or a description of that marker is required, and the goods and service of detail is also required, and priority detail is also required if we take the priority from the convention applications. So there is a different jurisdictions in India. Mumbai Patent Office, Mumbai Trademark Registry can file the patent trademark application. The Maharashtra, Madhya Pradesh, and Goa, and the Ahmedabad Trademark Registry, we can file the application which are situated in Gujarat, Rajasthan, the Union Territories of Daman Diu. Chennai Trademark Registry take the application from the Andhra, Kerala, Tamil Nadu, and Kolkata Trademark Registry take the application from Assam, Bihar, Odisha, Northeast, etc. And the Delhi Trademark Registry take the application of trademark application J&K, Punjab, Haryana, UP, Himachal, Delhi, and Chandigarh. And this is the form of trademark applications. And if there is a application for register or trademarks is already in use, so in that case we provide the trademark user affidavit, and through the trademark user affidavit the goods and service mentioned in that applications are already in use. And in case the use of trademark is claimed from the prior to date of applications, the application shall file an affidavit to testify to such use along with the supporting documents like the newspaper clippings, etc., GST bills, etc. Hence, the all trademark filing made currently in India require the user affidavit if they are the previously used is claimed. So when we file our trademark application, the register find the mark to be acceptable, and then the marka is published in the trademark journal. And when our marka is published in trademark journal, and the marka is open for the opposition for a period of 4 months, for anybody can oppose the marka. And if there is unopposed, the marka would then proceed for the registration. So in the workflow, for the requirement of the trademark application, we need the form for trademark application. This is the form trademark A in the 4 copies. The technical summary including the logo, marka, certification marks in the 4 copies, and the power of attorney in case of joint application is there. And in which class we have to file the trademark application, it should be in trademark applications, and the justification for the registration of proposed mark should be necessary. So when we file the trademark application to the trademark office, the official receipt immediately issued, and after formality check, the examination will proceed. And after examination report, our trademark application can be accepted or objected. If there is an objection in trademark applications, the trademark registry issued the first examination report, and we have to submit the examination report, reply to the examination report within the 1 month from the receipt of that letter. And if the trademark registry is satisfied with our reply, that's okay, then okay. Otherwise, it's given an opportunity to the hearing, and after the hearing discussions, our trademark application can be accepted or rejected. If there is a rejected, there is a provision to appeal in the High Court. If there is a accepted the trademark applications, our trademark application is published in trademark journal. And after that, the notice of opposition will started out, and there is a 4 month of the notice period. So within the 4 months of the notice period, anybody can, interested person can file that objection if there is a commendatory category of the objections. And if there is a no objection received by the trademark registry, our trademark application is the registered by the trademark registry, and the registration certificate will be issued. And after that registration, we have to renew the trademark applications after 10 to 10 plus years. So the ground of the examination is the two type of the examination grounds. One is the absolute, and the second is the relative grounds. Absolute ground means the non-descriptive distinguishes or descriptive grounds, and the customary or against the public morality, or having the religious connection, etc. Or relative grounds is the prior in term of use, prior registration or application date, or identical or a similar prior application or a registration covering the overlapping the goods and services. So the registration is calculated from the date of applications, and the valid for 10 years. And we have to maintain our trademark registrations, and renewal of fees may be filed 1 year prior to the date of which the marka validity is expiring. And application for renewal filed within the 6 months from the date of expiry of the registration. And there is also a provision of the restorations, means the application for renewal filed after 6 months and before 1 year from the date of expiry of the registrations. So there is a different case of the infringement of the trademark applications. Infringement means a trademark is said to infringe means when your registered trademark is used by the person who is neither the registered proprietor or licensee of the said trademarks. So this is the example, the Mercury and McDonald, both having the confusing each other. And the Mercury is take the unfair advantage or determine the reputation of the registered trademark of McDonald's. So this is the example of the infringement. So the Mercury is the identical or a very distinctly similar to the goods and service in respect to the trademark which is the registered in case of the McDonald. So, and it's like to cause a confusion to the part of public, or have the association with the registered trademark because of its identity or a similarity with the goods and service or a registered trademarks. And there is also an example of the head and shoulder or anti-dandruff, both having the size of the bottle is the same, the logo almost is same, and it's create the confusing, so confusing to each others. Go and Oreo, Yappy, Maggie. So all these are the example of the infringement and the passing of actions, because the no person can have the right to represent his goods as goods of another person, and they sell the low grade product with the logo of branded company. For example, the anti dandruff sell the low grade products with logo of Head and Shoulder. So the poor quality products pass off as a branded passing off, and it's the misrepresentation its goods and service that of the another to the customer of the benefit of the sales. So in case of this one, the likelihood to damage and loss of the reputation of particular company, and the under the passing of actions, the establish a goodwill or is a major ingredients. Or because in case of the registered trademarks, the in case of registered trademark, the infringement is if there is an infringement, in that case the person having the statutory remedy under to the act of the trademark. But in case of the unregistered trademark, it's a higher burden than the registered trademarks. And while under the infringement suits, the legal right is already available with the plenty of. So this is also an example of trademark infringement. The Honda Motor Company Limited versus Charanjit Singh Delhi in Delhi High Court 2002. In this case, the plaintiff is a well-known company, Honda Motors, and in field of motor car, having the presence in all over of the world, and they use the trademark Honda by responded dispetition, and they create a confusing in the minds of the public, and they sell the pressure cooker in name of Honda. So the court have restricted the defendant from the use of trademark Honda in respect of the pressure cooker, because it's create the confusing, because the Honda Motor is a well-known company in the field of the motor car. So and the other one sell the name of the Honda for the in respect of the pressure cooker. So it is the create a confusing to the and confusing in the mind of public. So in the trademark infringement, unauthorized use of the registered trademark to deceive the similarity, but in the passing is the misrepresentation of the goods and product to the deceive similarities. In case of the trademark infringement, the registration of trademark is mandatory or required, but in case of passing off, there is a no required of the trademark registration. But in the unregistered trademark, the user is the obligated to not only prove the similarity, but also the violation of the business goodwill also they have to prove. But in case of the trademark registered trademark, the burden of proof on the user. This is also another example of Superstop versus Vinod Superstops, and the Superstops have as we know the status of the well-known marka, and the sue have decreased in favor of plenty of, and the defendant was restrained from the infringement of the plenty of trademark and passing off and unfair competitions. Another example is the Pandit Kulfi Cafe and Pandit Kulfi, and because the respondent have written the word Sri Balaji in very small font and highlight the word Pandit Kulfi, and they just written a word as Sri Balaji below this one, and a bigger font in Pandit Kulfi. The customer may be misled that it must be a applicant. So the such name being very despectively similar to the registered trademarks, and the appeal was also allowed, and the respondent was prevented to use the word Pandit. And same the trademark infringement case of Amul. Amul, as we know, the very well-known trademarks, and in the Amul, the High Court judgment with the connection with the case under Kaira District Cooperative Milk Product. So one person have started their trading in the name of Amul Katpi Center, Amul Katpi store in district of Ahmedabad. But at that time, the Amul filed the sue against the Amul Katpi Center, and in April 2007, the district courts have passed a order that it is a clear case of the infringement because the Amul trademarks is a well-known trademarks, and the Amul Katpi Center is not related to the product of the dairy products. So they manage the brand, but they mislead the different class of goods. So, in the Trademarks Act, which is the amended in 2007, there is some changes in our trademark rules. Like the new form is introduced and replace the previously existing 74 forms. Change in the fee structure, 10% rebate for the electronical filing, expedite processing of the applications, and renewal request can be filed 1 year prior to the renewal fees. And time of filing is also start. Like in case of the evidence in support of the oppositions and applications, and evidence in the reply time period is also reduced for the 1 month, and specific provision introduced for determination of the well-known trademarks. So the new rule also allowed the determination and inclusion of the trademark on list of well-known trademarks, and the fees for filing the well-known trademark is 1 lakh rupees along with the statement of the case supported by the documentary evidence. And we have to determine whether our marker is well known. The registrar shall take into account to provision which find the mention under section 11C of the trademark, and the registrar may also invite a objection from the general public before determining a marker well known. So in international trademark filing, we adopt the Madrid system, because the Madrid is just like a PCT system and the major international system for facilitating the registration of the trademark in multiple jurisdictions. And because through the Madrid system, we allow a trademark owner to obtain a trademark protection in many jurisdictions by filing a one application or in a one jurisdictions. And we have to provision for the make any changes like the change of name, address, or a renewal registration across the all applicable jurisdictions. And there is a coverage of international registration may be extended to additional member jurisdictions at the time of that one. So we can file the trademark application through national route, regional route, or a international route. National route, we can file each country where you seek the protections. In a regional route, there is some country is a member of regional person, like the African having African systems. The country member of regional trademark system like the African Regional Industrial Property Office, Benclass Trademark Office, etc. And through the international route, the we adopt the protocol and the Madrid system, which are administrative by the WIPO, and our 70 countries are member of the international Madrid system. So next one is the industrial designs. So in this picture, we can see that there is a different design of the fan, design of the suitcase. Same the we can see the Lenovo. Lenovo is the best example of the design because the Lenovo tablet introduced a award-winning yoga tablet and launched in 2014 and incorporate the new technology and designs features. And through this Lenovo Yoga tablet, they covered by over 100 patents, application and design right in the single Lenovo Yoga tablet. So through the industrial designs, the in India, the industrial design is governed by the Design Act 2000 and Design Rule 2001, which are also amended in 2014. Same the patent application and trademark applications. The design law also is a territorial in nature, and we have to file the design application in specific country for the shipping protection of a design. And in India, the follow the first to file principle for the design applications. So when we file the design applications, so first thing come in our minds that what is the article. So the article means the any part of article which are capable of being made and sold separately. So it can be a safe, it can be a configurations, pattern, 2D pattern, 3D patterns, or it should be a very solely in a eyes, and it should not it shall not be a work of architectures like the any building or a structures having the artistic characters or a designs or any models for a such building or structures. So for this one, the architectural work is not a subject matter of design filing. But so when we file the design, we should keep in our mind that our design is a novel or a original in nature, and it is a prejudicial to the public order or a morality, or it is not harm to the security of India. And it should not be include the jackets, calendar, certificates, forms, documents, or dress making patterns, maps, plan card, postcard, stamps, medal, label, tokens also. And the application for registration of design is not registrable if these are the contrary to the public order and the morality. So the stamps or a book stamps or a credit card, etc., is not a subject matter of design filing. The labels, token, card, cartons, part of articles, so not sold separately, it cannot be registered. So when we file the design applications, it's the design also having the aesthetic value or a visual appealing. So in case of the sofa, dinner sets, snacks, textile patterns, or a car, these are subject matter of design filing. In this case of car, there is a several things we can file as a design, like the design of car seat, design of headlight, and design of tail light, design of the side view mirror, design of tires, etc. And the surface ornamental on the tire is also a subject matter of design protection. But the bumper is also a subject matter of design protection. But the bumper should be without logo, because where there is a logo is a subject matter of trademark filing. So the bumper which without logo is the subject matter of the design filing. So in the India, the design office is situated in Kolkata, and there is a 4 branches in Delhi, Mumbai, Chennai, and Kolkata. So who can apply? The any person claiming to be a proprietor, or the design should be a new or a original, and which are not a published in any country, and which are not a contrary to the public order or a morality. And if there is design is not a new and original, we cannot file the design applications. It is not a significantly distinguished from the known designs, or a combination of known design, we cannot file the design applications. So novelty is determined on the global basis, just like the patent application. When we file the patent application, we see the novelty in the global basis. So novelty means the no identical design has previously been made available to the public, in term of the conferencing proceeding, in term of the lecture proceeding, or in term of the patent filing, etc. So the design are deemed identical if their feature differ only in the immaterial details. So there is a different type of the design applications in ordinary applications, or a respiratory applications. In ordinary application, there is not need the claim priority, but the respiratory applications claim the priority of the application filed previously in the convention country. And the period of for the removal of the objections shall not exceed the time period of the 6 months from the date of filing of the applications. And the substitution of the applicant or a joint up claiming, the claim for substitution is made before the design has been registered. So there is a several ground of the rejection of the industrial design applications. If there is does not meet the requirement of novelty or originality or individual characters, or if the technical function of the product is not satisfied, such that technical and functional design features is still protected, but the other IP right, like the patent, utility models, or a trade secret, in that case your design application will not granted. And incorporate the protection official symbol or emblem, such as the national flag, is not a subject matter of design protection or granting, and considered for the contrary to the public order or a morality. So when we file the design application, there is a requirement for the we need the entity status, like the natural persons or a other than natural persons, which include the small entity or a other except like the small startups, etc. And we need the power of authority if there is a educated by the authorized signatory of the applicant. If there is a priority detail is also needed, submit the documents with the application forms, and assignment deed is also needed for filing the design application. And when we file the design application, we need the name and address of the applicant, and we also provide the representation sheets. And representation sheets means, if possible, we have to give the perspective view, front view, rear view, top view of that objects. And application can be filed with line diagrams and computer graphics with photographs. And drawing contain the shaded, dotted, broken line are not allowed. So we need the particular design in enlarge and a cross-sectional view, which are not allowable. So this is the example of the representation sheets. That this is the example of the suitcase representation sheets. We have to show the represent perspective view. We have to show the front view. We have to show the rear view. And we also put the line that novelty reside in the safe and configurations. We are not talking about the novelty of the manufacturing of that suitcase. We just talking about the novelty which reside in the safe and configuration, because when we file the design application, we are not talking about their technical feature. We are talking about their static value, or the things which we are easily visualized through the eye, naked eye. So the no in this case, the novelty reside in their safe and configuration of the luggage as illustrated, and no claim is made by virtue of this registration in respect of any mechanical or other action of the mechanism with respect to the suitcase. Same, the we have to show the side view of that products, top view, bottom view, when we file the design applications. Same, the in case of the trademark application, there is a several class. Same in the design filing, there is a class. For examples, in India it is not possible to file the multi-class application. For in case of the motor cars and the toy car, we have to file the separate applications and with the separate classes, because like the tire come under to category of 12-15, which cover the tire and anti-skid chain for vehicles under the heading of the means of the transport or a hosting. Same, the wristwatch 10-2, which cover the watch and wristwatch under the heading of the clock and watch and other measuring instruments, checking and signaling instruments. So there is no provision of the multiple embodiment in design filing, and no provision of the filing a multiple or a divisional design application in India. If there is a multiple design in particular design, we have need the separate application for the each and every design. For this one, if in this design there is a design of monitors, monitor stands, notebook computer, and docking stations, we have to file the separate design application for each and every part. Monitor designs also we have to file separate application. Monitor stand, we have to file the separate application for design protection. Even the notebook computers also have the separate application for the design protection. Same, the this one, because in this case you can see in the figure one, there is a 4 electrical terminal connected in the series, but when we file the 8 holes at the front, we have to file the different design application. Same, the all 8 hole at the front along with the cavity at the top, we have to file the different design application. So if there is a multiple embodiment in particular design, we have to file the multiple applications. So same in the below figures, we have to file the separate application for the light design. We have to separate application of the mirror design. We have to separate application for the flash design, shutter buttons, viewfinder, screens, and sensor plates, shutters, mirrors. So different parts we have to file the different design applications. When we file the design applications, we need the Form 24 representation sheets with perpetual design of object and the statement about the novelty. And after the design filing, the formality check and substantive examination will by the design office, and we have to give the reply of particular objection if there is, and within 1 to 3 months from the filing. After filing the response, the controller of the design, you think that our response is underway, that is okay. Otherwise, it give the opportunity to the hearing again, and after hearing discussions, your design application can be accepted or rejected. If there is accepted, they issue the certificate, and publication is also come in the official journals. And after that, we have to renew of the design application, term is 10 year, by the extendable further by the 5 years. So the total validity or validity period of the design application is the 15 years. And this is the specimen of the representation sheets, and registration for the period of 10 year from the date of applications, and the term of design protections may be extended only once by the further period of the 5 year. And the restoration is also possible within the 1 year from the date on which the design registration is expired. And the same in the trademark application, when we file the design application in international, then there is a 3 routes: national route, regional route, or a international route. In the national route, we can file the our design application is a particular country, in each country in which we are seeking for the protections. In regional route, if we want our protection of the design application in group of country which the member of intergovernmental and entities, in that case we can file the regional routes, and in through the international route we can file the patent trademark application through the Hague system, WIPO Hague systems, and the 70 countries is the member of WIPO Hague system, through which we can file the one design application in the multiple countries. So next one is the copyright. So copyright is also a term of intellectual property rights. In intellectual property rights, the copyright is the exclusive or a legal right to reproduce, publish, sell, and distribute the matters and form of something, so that no one can else use copy of our work. So the copyright is also just like a trademark, a patent, and all IP intellectual property is also a negative rights. Copyright also is a negative rights, and there is a several type of the copyright, like the literary work, computer software, cinematography work, artistic works, sound recording works, musical works. So in case of computer programs, we have to sell or give a commercial rental, or offer to the sell or a commercial rental any copy of the computer program, like the MS Office, or Acrobat readers. All these are the common category of the computer program. Artistic work, the story of its any medium by electronics or other means, or a three-dimensional or a two-dimensional works, or which in the copyright is also include the cinematographic film. It's also include the issue copy of the work to the public, not being copy already in the circulations. So in case of the cinematographic film, where it's give the right to the make a copy of the film, including the photograph of the any image or a story of that ones, or to sell or give a commercial rental, or a communicate the film to the public. Or in case of the sound recording, it's also give to the right to the person to communicate the sound recording to public. So there is in a specific provisions in the copyright shall not substitute under this act any designs which is registered under the Design Act. If we have filed the design application of any object, it is not a subject matter of the copyright filing. Or copyright is in any design which is capable of being registered under the Design Act 2000, but which has not been so registered, shall cease as soon as the any article to which the design has been applied or reproduced more than 50 times by the industrial process by the owner of copyrights. And in term of the copyrights, the term of copyright in published literary, dramatic, musical, and artistic works. And in the copyright example, like the literature, in case of the novel, short stories, essay, poem, manuscript, and the articles, computer software, and smartphone applications. The music means the musical notes, melodies, lyric, all these are come under category of the copyright protections. The sound recording, like the podcast, DVD, CDs, are also a subject matter of copyright protections. The graphics, or photographs, map, diagrams is also a subject matter of copyright protection. Even the architectural work is also a subject matter of the copyright protections. So in the architectural artistic works, a painting or a drawing, or including the photographs or a artistic quality, come under category. In the sound recording, a recording of the sound from which the sound may be produced regardless to the any medium is come under to category of the sound recording. Or it is we can file the copyright application of the songs, recorded speeches, or a audiobooks. In the literary work, literary work means the expressed in printing or a written form, or in form of notable or a symbol. And in the case of the dramatic work, there is a distinguish between the literary and dramatic work. The literary work include but are not limited to the textbook, poems, magazines, catalogs, letter, novel, or a lyric of the songs. But in the dramatic work, including the play, screenplay, scripts, and the choreographic notation, etc. So in a cinematographic, the any work of the visual recording, or including a sound recording, or a cinematic graph shall also be constructed, or as including any work produced or by any process of the including video film. Music work, like the a work consisting of musics and including any graphical notation of such works. So in case of this one, there is a several type of the copyright application we can file. The script is also a come under the copyright protection. Even the song also a come under the copyright protection. Singer is also a come under the category of the copyright protection. Costumes is also a we can file the copyright application. Lyric, musics, all these are come under the category of the copyright protections. But we cannot to protect the ideas, fact, data, concepts, systems, method, principle, and discovery under category of the copyright. So the copyright does not protect the idea or concepts, and the government work created by the government is also not a subject matter of copyright protection, or the work without original authorship is also not a subject matter of copyright protection. Even the facts and the research result is not a protection of copyright protections. So there is some in our mind that copyright is automatic or we have to file the copyright protection. So since 1978, the any new work created have the copyright protection as soon as they are in the tangible form, and there is no need to include the copyright notice. So the work created after 1978 has the copyright protection lifelong or until 60 years after the death of the authors. And the work created between 1923 and the 1978 has copyright protection for 95 years. And the work created before 1923 is in public domain. There is no need of the copyright protections. So when we file the copyright applications, we can file our copyright application to the registrar of the copyrights, and there is a several form for the needed for copyright protection copyright applications. Part 1, part 2 for musical work, part 3 for the artistic work, part 4 the cinematographic, part 4 the sound recording, part 6 for the computer programming, etc. So in the registration of the copyright, the application for the registration of copyright means the every application for the registration of copyright shall be made in form 14, and every application for the registration changes in the particular of the copyright enter in the register in form 15. And every application should be signed by the applicant, and application should be unpublished work shall be accompanied by the 2 copy of the work. And every application for the registration of the computer program, at least first 10 page and last page of that source code and object code is needed, and if there is a less than 20 pages. So there is a provision when we file the registration of the copyright applications, we file the application in form of form 14 to the copyright office, and after that the examination of application will be going on, or if there is an objection, in that case the copyright office give the hearing notice to hear to person, and after that the satisfaction of the response of which we have provided to the copyright office, the registration certificate will be issued. So through the copyright registration we have to obtain two type of the right, economic rights and the moral right. Economic rights means we can sell, we can earn the money from publishing. We give the right to the economic right to the other licensee by publishing, performing, selling, distributing, hiring, or licensing in different form, or assigning. Or through the moral right means under section 57 it is very clear that which allow the author to take a certain action to preserve the personal link between himself and the other and their work. So there is also one right now one word in common existence, the copy left. So the copy left is just like opposite to the copyright. Copyright is the legal exclusive legal right to use and copy and distribute the creative work, but the copy left is the arrangement whereby the work may be used, modified, and distributed freely. So there is a difference of the copyright and copyleft is copyleft is just like the Acrobat Reader. So, in Acrobat Reader we can download the Acrobat Reader from the Acrobat sites freely. There is no need to pay anything for the download the Acrobat Reader. But when we download the Microsoft Office or a window, we have to pay for the Microsoft Office and the window. So the window, Microsoft Office, all these are the common category of the copyrights, and the Acrobat Reader which are the freely available to the public is the example of the copyleft. So in the workflow of the copyright protections, we need the original copies, and in case of the software, we need the source code and object code in 3CD. The statement of author is also needed, and if there is a prior publications, we need the relevant details, and the justification is also needed. And after filing the copyright application, the Copyright Office issue the diary number, and the 30 days mandatory waiting period for objection is in case of copyright registrations. If there is a no objection, after that the scrutiny by the examiner, and if there is no discrepancies, our copyright is registered, and the registration certificate will be issued. Or if there is an objection, they have received them by the some other person, and after that the both parties sit together, and the decision will be made by the copyright registrar of the Copyright Office. So this is the certificate of the copyrights. And in case of the
So we will wind up in 5 to 10 minutes, and we will take the questions from the participants. So,
within a 5 minutes,
yes.
ma'am, I will finish. So in case of the infringement of the copyright, so when any person without a license granted by the owner of the copyrights, or a registrar of the copyrights, and does anything the exclusive right to which the act conferred upon the owner of copyrights, and when the any person make or a sell or a hire or a distribute either for the purpose of trading purpose or by way of trading exhibit in the public, it is also a category of the infringement of the copyrights. So there is a exceptions of the infringement, means the fair dealing with any work and not being computer program. The private or personal use, including the research and teacher to students, is not come under category of the copyright infringement. Criticism or a review whether of that work of any other work is not a subject matter of copyright infringement. And the reporting of the current events and the current affairs, including the reporting of the lecture delivered in the public, is not a subject matter of the copyright infringements. So in the Copyright Office, there is a following index. In the electronic forms, in there the general author index will be there, a general title index is there, a author index of work in each language is there, and the title index of the work in each language. And the research study, critical review, reporting of the news, and giving the professional advice by the legal practitioner of a patent attorney is not amounting the infringement of the copyright acts. And we have to give the license to the particular company or another one for earn the money, and we have to use the symbol C in circle for the copyrights. And there is also a compulsory license in the work within from the public, and author to work the desire to reclude under section 21 of any other rights which is given to the person to other one. So the main motive of the copyright protection is the we have to earn money, we have to sell our we have to give the license to the other person to the earn money. And if there is no copyright exist between and but cannot be enforced, the above still happen eventually. And if author cannot make a living writing, most of will not writing, or even a movie company cannot profit from the movie, they will hire very few actors. So this is the example of the trademark and copyright and design distinguish. If there is a there is only a word, we can file the trademark application. If there is a label or packaging, we can eligible for the filing trademark, even the copyright. And if there is any object having the safe, we can file the design application as well as copyright and trademark. But we have filed the design application, we need the novelty. But in case of the copyright and trademark, there is no need of the novelty. So there is a difference of between the trademarks and copyrights. And in trademark, there is no need of novelty, no need of novelty in copyright, but need the novelty in design. And the tenure is 10 plus year in trademarks, lifetime for 60 year for copyright protection, and 10 plus 5 year for the design applications. And this is also an example of the cup of tea. In cup of tea, we can file the several type of the IPR. In the copyright, we can file, in the patent application, we can file GI application. When we file design of particular tea product, we can file trademark application. We also eligible for filing. And this is for my credits. And this is from the disclaimer from my sides. And thank you, ma'am. And I'm happy to have a question from audience, ma'am.
Thank you so much, sir, for such an informative session. So, dear participants, if you have any query, you can write in the Zoom chat or you can raise your hand. We will unmute you. Right. So, sir, there is one question in the chat. There are cases where names are differentiated by just an alphabet. For example, only coffee, ONLY, and only coffee, ONLI.
Yeah,
So,
ma'am. This
how
is a,
will such infringements
yeah.
with respect to trademarks are dealt?
Yeah, this is the case of infringement, ma'am, because they are both word only coffee and only coffee are confusing to each others, and any person which have the registered trademark of the only coffee, it can file the sue of the infringement, ma'am.
Yes, sir. Thank you, sir. Yes, Mr. Rajesh, you want to ask anything?
But sir, does IPR include trade secret and moral rights?
Yes, state secret means just like Lay's chips, Pepsi. They don't secret their recipe because there is a difference of the trade secret and patent application is that in the patent application after 20 years because they have some validity. After the expiry of the 20 year, all your recipes, all your process, how you prepared is commanded in the public domain. But in the trade secret, your particular things is kept into the secrecy and no one can use no one can disclose the particular recipe or a particular composition of your products in public domain. So the big company like the Lay's, Pepsi, Coca-Cola, etc., they are using they are prefer the trade secret compared to the patent application because they think after 20 years their product coming into the market or anybody can free to manufacture of that one, so they are kept secret of their compositions.
Thank you so much, sir.
Yes, anyone else from the participants? We can take some queries from the Zoom chat as well. If you want to write any query in the Zoom chat, sorry, not on the Zoom chat, YouTube chat. Yes, sir, there is one question. How is trademark different from brand name in terms of distinction between products? It is by
Yes,
Amreen Makbul.
it's just like
Yes.
ma'am, Maruti. Maruti is just like a brand. Okay. And the trademark is a Maruti Baleno, is also a trade of Maruti Suzuki, Maruti 800. So Maruti and 800, Maruti Suzuki, Maruti Brezza. So Brezza 800, all these are the trademark. And the Maruti is the brand. Maruti is the brand and the trademark is a Maruti 800, Maruti Brezza, Maruti Baleno. These are the trademark.
Yes, sir. Thank you so much, sir. Anybody else? If you want to ask any query, in the YouTube link, there are no queries. Yes, anybody else? If they want to ask any question, they can raise their hand. Okay. So no queries in the Zoom chat, sir. And everybody is writing very informative session and very interesting session, very clear concepts and everything, sir. Thank you so much.
Thank you,
So,
ma'am.
sir, could you please stop sharing your screen,
Yes,
sir?
sure, ma'am.
Yes, sir.
Yeah.
So, okay, sir. So, no more questions are there. So, I would like to give a formal vote of thanks, sir. So, on behalf of the whole KMV IPR cell and KMV IIC, I am Dr. Narinderjeet Kaur. I extend heartfelt gratitude to you, sir, Dr. Kapil Arya, sir, for your enlightening lecture on the essentials of copyright, trademark, and industrial designs. Your depth of knowledge and clear explanations have truly enriched our understanding of these crucial aspects of intellectual property right. So, we are grateful for the time and effort you have invested in sharing your expertise with us, sir. And, sir, your insights will undoubtedly guide us in navigating the complexities of intellectual property law with confidence and clarity. And we appreciate your dedication to shedding light on such intricate legal subjects, empowering us with valuable insights and practical knowledge. Your passion for the topic and engaging delivery style made this session not just educational but also enjoyable. So we look forward to implementing the learnings from today's lecture, sir. Thank you so much. Thank you so much, sir. Thank you. And I would like, at the end, I would like to thank our President, KMV IIC, Dr. Rashmi Sharma ma'am. She is always a pillar of strength for us. Our worthy ma'am principal, Professor Atima Sharma Divedi. She always motivates and encourages us for such organizing such events. And I would like to thank Shashi sir for their technical support. Thank you so much. Thank you, dear participants, for joining us. And we will be back tomorrow also at the same time. Thank you, everyone. Thank you. And feedback link is shared in both the platforms.